Say what?
Yeah. You're live.
Get that all.
I think I gotta go here.
Big touch. Good morning. This is the Legislative Committee on Administrative Rules, February 24th. We do not have a quorum. We have a couple senators who are online. It's my intention to take the testimony today from the witnesses on the three rules we have before us and vote on them the next time we meet when the other members of LCAR feel comfortable enough to vote. So we're going to start now, and we'll introduce ourselves, the three of us that are here. I'm Mark McDonald, I'm the chair of LCAR, and I represent Orange County in the legislature.
Seth Baumgartz, I represent Bennington 4, Arlington, Manchester, Sandgate, and Sunderland.
And Mark Higley, I represent Lowell, J, Westfield, Troy, and the town of Eden.
And we have on Zoom, but according to our rules, not able to vote unless they are physically present for joint meetings between Senate members and House members. And if you would please introduce yourself, Senator from Caledonia.
Good morning, everybody. My name is Joe Benning. I am the junior senator from the Caledonia District, which presently is all of Caledonia County and the 6 northeasternmost towns in Orange County. But after the next reapportionment, we'll likely be cut way down in that number of towns. But we'll see. Good morning.
And Senator from Addison.
Good morning. My name is Christopher Bray. I live in Bristol, represent the Addison Senate District, which is Addison County, Huntington, and Buell Score.
So we have 5 members of the committee listening in. Is Senator Lyons here on Zoom? Is Representative Odie on Zoom? Well, we cannot approve the minutes because we do not have a quorum to vote upon them. But Mr. Englander is here to speak to us on the first rule on the agenda, which is 21E22, Department of Health Emergency Administrative Rules for Remote Hearings for the Board of Medical Practice. Welcome, Mr. Englander, and the floor is yours.
Thank you, Mr. Chair. Good morning, members of the committee. My name is David Englander. I'm the Senior Policy and Legal Advisor to the Commissioner of Health. I'm here to talk about the emergency administrative rules for the remote hearings for the Board of Medical Practice. This is actually the second renewal of this rule. For a quick refresher, the Board of Medical Practice, which is the body that licenses MDs and PAs, sits within the Department of Health, although they are an independent board. This rule, the first emergency rule was adopted by the board at the beginning of the pandemic. This is the second renewal of that rule. It allows the board to conduct hearings remotely. This has 2 primary functions. One, it is to allow board hearings to be conducted safely in the time of continued COVID spread, as well as it allows providers who populate the board and who are, many of whom are involved in the COVID response, to save the sometimes significant travel time moving back and forth between their homes, offices, and the hearing room, which is in the Department of Health in Burlington. The department has filed a permanent rule that will codify this provision, so it will be permanent. So that's currently in the works. I should also just note briefly that there have not been issues with this rule. It largely replicates OPR's rule in order to also conduct hearings, and there have not been, as I understand it, there have not been issues there as well. So with that, I'd happily take your questions.
Questions for the witness? For those who may be listening in, you said this is the 3rd emergency rule on this topic. From reviewing the rule, I didn't see any changes other than the dates. And this was originally put in as an emergency rule to deal with the COVID emergency. which calls for people not meeting in person. I don't want to make light of this rule, but it seems like it's the same pitch that the last two rules were, with no changes other than the dates. Is that correct?
That's correct. So this emergency rule provides continuity with the previous rule and will be the bridge to the permanent rule.
And were not emergency rules limited in time, we wouldn't have had to have this third meeting to do the same thing for the third time. I'm saying that for the record, both for folks listening in, and when we meet as a committee to ratify this, when we have a quorum, we'll be able to report that. So, do you have anything else you'd like to share with us before we move on to the next rule?
I don't, but I'm happy to take any last questions.
Well, are those parking meters behind you in the?
Those are owls.
Pardon?
They're owls.
Owls. Okay. It looks like.
That is.
This is when I expect my colleagues to say some embarrassment and say, "Oh, actually, they do look like parking meters."
I'll be honest with you. I briefly didn't know where I was.
Wait, we didn't know whether you were a cool hand Luke.
Precisely.
Okay, so thank you, Mr. Engler, for testifying this morning.
Thank you. Here.
Our age will understand that.
No failures. The second rule on our agenda is presented to us by the Cannabis Control Board, and there are rules for licensing of cannabis establishments. The rule number is 21P38. We have two witnesses this morning: David Scher, Assistant Attorney General for the Attorney General's Office, and David Silberman, attorney from Middlebury. Mr. Scher, the floor is yours.
Thank you very much, Mr. Chair. Thank you very much to the committee for having me here today. I'll give a few introductory remarks here that will give some context about the broader regulatory environment that the board is building. Rules 1 and 2 are not the sole rules that are going to be coming forward. A few words about the process and some of the documents you've received. And then after that, open it up for questions. I do want to be brief as I can be in this context section here, because I want to be sure that I'm saying things that the committee is interested in hearing, and I know that questions will elicit that. First and foremost, I want to note that these are the first two of a planned 5 rules that the board will be putting forward. These are not the only rules that are coming. Rules 3 and 4 are actually in public comment right now. Rule 5 will be coming through the process soon as well. As you know, rule 1 is licensing. Rule 2 is the general regulatory scheme. Rule 3 will be about the therapeutic use of cannabis, essentially the sort of transition of the medical cannabis program to the board. Rule 4 will be about compliance and enforcement. What are the enforcement mechanisms going to be for rules 1 through 3? And then Rule 5 is a sort of standalone rule specifically about board removal, which was a required provision in the statutes that the board has to make a rule about how to remove other board members, but that's coming down later and is a little bit different than the other regulatory rules. A couple reasons on why they were divided this way. First and foremost, to make them as usable as possible. We really tried hard to design things that somebody could look at the titles of and understand what is in there and could know where to go when they're looking for information. But secondly, we also were designing around the tight timelines that we have here and trying to get this up and running in accordance with the legislative mandate to open applications in April. And we understood, and the key pieces for those initial applications were, of course, the application requirements and the general regulatory rules of the market, which needed to come out in order to allow people to have sufficient knowledge to apply and know what they were getting into. A couple notes just on the process of these rules, how they came forward. I do want to note, as it does say in the materials you have, these have been marked by extraordinary public input before the rules were even promulgated. There were many hours of board meetings, of advisory board committee to the board meetings. There was public hearings. There was a lot of input that the board got. The board always intended and in fact did use the notice and comment period as an opportunity to improve the rules. I took that very seriously. Rule 1 had 80 substantively distinct comments. It had more than that, but it had 80 substantively different comments. I know we're doing Rule 1 first, but I'll note Rule 2 had something like 180 substantively distinct comments. And over the course of several weeks, the board, 2 weeks, I think, the board met for more than 16 hours considering all these comments. On Rule 1, the board did accept in whole or in part about half of the comments. Rule 2, that was about a third of the comments were accepted, at least to some degree. There were changes made in response. And I just bring that up to note that this really has been a publicly informed and robust public process. And I think the rules are much better for it. Some of the reasons why rules were not, they cover such a broad spectrum of subject matter. It's hard to boil it down to one overarching theme. But I would say that if there is one, it is the difference between the viewpoints of the regulator and the regulated. The regulator obviously has to keep in mind public safety, public trust, public health issues. And that's not to say that the industry representatives we heard from don't care about those things, far from it, but just that there are different weights that are assigned at times. And the board had to assign sufficient weight to those types of issues. And that's where there were disagreements. And there were, of course, other sort of more technical things there as well. A couple notes on the supplemental documents that you've received since then. Obviously, we submitted 2 supplemental documents. One, I'd say of the 5 proposed changes, 4 of them are really fairly technical changes. And I'd say the 5 between the 2 documents that we submitted. One, I'd say really all of them are. I did want to just note the tax one, which was that did come from the tax department. I did want to be clear with the board that we have been the board has been very careful to work with the agencies that will be affected. We did have the tax department comment on our rules back in December. They apologetically noted that they had missed this one issue. And I will note the board accepted all of the tax department's recommendations when the tax department first reviewed the rules. They did apologetically note that they had missed this one. And so we're happy to make this change and submit it to the committee for consideration as well. They didn't catch it until after we'd filed, obviously. I know that Attorney Silverman has submitted a memo. Again, I will limit my comments on this one because only one of those issues had to do with Rule 1. I will note that most of those issues were things that had been brought that the attorney and others from the cannabis industry had brought forwards. They were substantially similar to comments that the board did consider and did choose to reject. Ultimately, these are policy disagreements between the regulators and regulated. I think that they embody that. There's some also, I think, technical disagreements about how the rule is likely to actually work in operation. The issue on Rule 1 here with respect to the opportunity to overcome criminal records issues. Again, this is substantially similar to a comment the board already considered, and the board does feel that within the rules, there already is an obligation for the board to solicit any sort of mitigating circumstances that somebody might wish to put forward. So the board felt like that was already taken care of in the rule and did not choose to move forward with recommendations along those lines, making alterations along those lines. And the final thing I'll just say before opening it up is the board has been very clear that they understand these are new rules. The market doesn't exist yet. We don't know exactly how things are going to play out. And they have been very clear that they will be reopening these rules probably within the year, maybe the end of this year, early next year, once the market is fully operational, to take into account whatever changes, whatever things that experience has to teach us, which I'm sure experience will teach us a lot. So I did want to note that these are, the board is very aware of the need to make further accommodation once we learn more about what's happening. They're not approaching these as something that is set in stone, but rather as the first step. And we will be back in front of this committee probably in about a year with some updates to make sure that this is working as well as it can. So with that, I'd open it up on Rule 1 and happy to entertain questions.
Representative Higley.
Thank you, Mr. Chair. Thank you, Mr. Shearer, for being here today. A lot to digest here. As you said, there's a few other reports and recommendations coming in. So again, I do have a few questions though. In looking over the documents that I have here, when you talk about 80 some individuals giving testimony, to me, it looks like a lot of the recommendations that were made and even accepted weren't necessarily from your average individual. And I'm wondering if you are familiar with just what groups did testify, because again, they seem to have quite a technical knowledge of the industry. And that's my first question is are you aware of who these folks were that testified? Were they Vermonters, out of state? Were they organizations?
Sure, it's certainly the case. Well, first let me say, I don't know everybody. You know, we had comments that came in through the public portal and our public portal on the website. So we don't know exactly who everybody is. I will say that, but we do have a general sense of where a lot of them are coming from. I do think that the vast majority were Vermont. People are currently in Vermont in terms of their location. There certainly are people who have very serious technical knowledge about these issues, and that is reflected, as you note, in those comments. And some were people who are currently involved, I think, in the medical industry. Some, I think, are currently involved in the illicit market, is my guess. I don't know that, but that's my guess. Some were, we also had people coming from the public health side. We had a number of comments, obviously, from folks from the Vermont Medical Society and folks on that end of the spectrum. And we had a number of people commenting who have been involved in, I think, I'm sorry if I already said this, but the current therapeutic medical sides, there's a lot of people who are caregivers. And actually, let me emphasize that now that I think about it, there were a lot of people who commented who are currently involved in the current medical program, where you have caregivers and patients who are have serious cultivation experience and some manufacturing experience. So I'd say that's an overall picture. I didn't have a sort of systematic breakdown, but that's a picture. And some of what I'm saying is a bit of my impression. You know, people were not required to specifically identify where they're coming from, although a good number did. So some of that's my impression. So I don't want to characterize that as the definitive answer, but that's a general sense of where people were coming from.
And if I could follow up, Mr. Chair. So another concern that I have is some of these suggestions to me when listening to the floor debate and proposing changes on the floor while through committee, but I'm wondering, and I didn't see it, maybe I missed it, but is there a recommendation from the committee's jurisdiction in regards to approval of these rules?
I didn't.
I guess that's a concern for me. Again, we generally have a recommendation from the committee of jurisdiction over whether or not it meets legislative intent, and I haven't seen that. And again, just from my recollection, there are some things around in particular. There's so much information here, I'm not even sure it's changed, but one of the issues is around packaging and safety, health information on those packages and so on. And I know that that was a critical issue for some in the House. So I would be very interested to see the information from those committees. Government operations, I believe.
That's right. And I have reached out to the chairs. I have not heard back with respect to any recommendation or concerns. A couple points on that. It is certainly the case that the board, we believe, was very careful to stay within the legislative intent and to do all of the both do and refrain from doing the things that we were required to do and forbidden from doing by the legislation. With respect to the health warnings, the board was required to consult with the Department of Health, and the department did approve the warnings that are in the rules. We had requests to change those in the notice and comment period, and the board refused to do so because they wanted to stick with the recommendations of the Department of Health. And we do think that the packaging requirements, which are significant, this is actually more of a Rule 2 issue, but the packaging requirements are significant, and we do think that they embody the legislative intent that there be a lot of care around packaging, around child-proof packaging, around warnings, around clear content labeling, around chain of custody requirements. I mean, I think the board actually went beyond what the legislature required in terms of safety on the packaging issues.
Thank you. Thank you, Mr. Chair.
There are 5 rules that are part of a package. The committee has received 2 of them. For the listening public who might ask, why do you have 5 separate rules for this industry that is being created new and following on the heels of the existing medical cannabis? Could you share with us just what the 5 are and how they differ and what their categories are?
Sure, yeah. So the first is licensing, which is how do you get a license to be a business in this new market. The second is regulation of the businesses. What do you have to do as a business? What can't you do as a business? What sorts of reports do you have to require? What sorts of records do you have to keep? All of those sorts of things are in Rule 2. Rule 3 is about adapting the currently existing medical market to the new world where we're going to have a legalized adult use market, and kind of melding those two areas together while maintaining a separate set of rules that are pertinent to patients and caregivers, which they do have permissions to do things that the regular adult use market does not have in terms of the products, also in terms of delivery, curbside, things like curbside delivery, things like that, that the adult use is not currently permitted to have. So melding those two while leaving the carve-outs that exist. The fourth rule is compliance and enforcement. What can the board do if somebody doesn't follow the rules, any of rule or something in rules 1, 2, or 3? How do they do that? What are the processes for doing that? What are the penalties that are available? Investigation, duty to comply with investigations. All of those sorts of things are in Rule 4. Rule 5, again, as I mentioned earlier, is kind of a special rule in the sense that it isn't directly related to the regulation of the market. It is a requirement in the legislation to create a rule around board member removal. The legislation did empower the board to remove its own member. 2 members of the board could remove a 3rd member for cause, and defining how that process is going to happen if it needs to happen is in Rule 5. And part of, we could have done this all, I suppose, as one giant rule. Part of it was the exigencies of timing, but part of it also is that we really did feel that it was easier to follow and understand, to divide the rules up into these categories. We did really make a serious effort to make this whole regulatory system something that is going to be relatively usable. I acknowledge that there's no way to avoid some legalistic language when you're designing rules. You need things that are going to stand up in court and that are precise. So that is in there, I acknowledge, but we tried to design the whole body of the rules, all 5 rules, as something that you could say, all right, I need to know about the medical program. Where to go? Oh, that's rule 3. Boom. Let's look at the table of contents to rule 3. Where do I find stuff about caregivers? Oh, that's how you register as a caregiver. So I think we made a real effort. Or, take rule 2. I'm a manufacturer. What do I have to do to abide by it? All right, look down the list. These are the things that are applicable to all cannabis establishments. And then here's the section that's applicable to manufacturers. I can ignore all the stuff about retailers, cultivators, and so forth. So we really tried to make them usable. And that's why there's 5 of them. Try to divide it up in a common sense way, and then divide up the table of contents in each rule in a fairly common sense way as well.
Thank you. The witness has reminded us of our time in middle school when we were told we had to learn outlining and its usefulness. So we've got 5 different categories. And we've taken your testimony here on the first of these 5 rules. And when we finish these questions, you will, the first being the licensing, licensing, and the second one being the regulation of how the establishments operate. Those being the first 2. So are there any further questions on this one? So for those that are keeping outlines, we've just done Roman numeral 1, and we're now going to go on to the next rule. Are there any folks members of the committee on Zoom that have questions? If not, Senator Benning.
It's not a question, Mr. Chair. I am going to agree with Mr. Higley that it would be nice to get responses from the committees of jurisdiction. But I also want to give some credit to the folks who are on the screen for a moment. They are only the latest in a long series of individuals who, as Mr. Silberman reminded me earlier, the official bill was 6 years ago that we passed, enabling a change in the culture around marijuana. And it was a couple of years before that, before we got that bill through. And through that time period, both the Government Operations Committee in the Senate, as well as the Judiciary Committee in the Senate, spent considerable time on the road going around Vermont, taking testimony from virtually every quarter on this subject. We heard from everybody who was opposed and everybody who was for, and at least Michelle Childs, who I see is on the screen here, was with us through all of that testimony. And the folks who are now presenting this rule are just the latest of some folks who have been in a long chain of individuals. But I want to give some credit to them for taking this task on and to develop a rule that for the first time Vermont is going to have to deal with. It's not going to be perfect. I don't expect it to be, but the task in front of them is to make sure any product that is sold is, number 1, safe. Number 2, does not gain access by those who shouldn't have it, is tested on a regular basis, is controlled in the business environment that we expect it to be. And I just wanted to take that moment to say that I've watched it all from the beginning. And this collection of rules that's now in front of us is incredibly complex in relation to all the things that have to work as a machine. So I'm very happy to see it develop, and I'm looking forward to seeing it develop the right way. But there is some fair comment that we need to make sure the committees of jurisdiction have weighed in on the subject. Thank you, Mr. Chair.
Thank you. And those listening can be assured that when we take this up for a vote, when we have a quorum, the committee's chairs from the committees of jurisdiction will have spoken with us, and we will have their comments. So thank you. And the next witness on the first rule, Mr. Silverman from Middlebury, are you ready?
Thank you, Chair McDonald and members of the committee for having me. My name is Dave Silberman. I'm an attorney in Middlebury. I've been involved in the efforts to legalize cannabis since about 2015 in front of many of your committees over the years. Once Act 164 was passed or went into law, I began a cannabis law practice out of my small firm, Silverman PLC. I currently represent multiple would-be applicants for the various types of licenses that would be regulated by Rules 1 and 2. I mentioned that by way of saying my testimony today is certainly educated by conversations with many of these clients. However, I'm not here on behalf of any particular client, and my views are not meant to be understood as representing any particular client. And my goal here is to, as it has been for the past 7 years, to help build a well-regulated industry that works for all stakeholders, most importantly, consumers. As a preliminary matter, I just want to commend the board and its staff, including Attorney Scher, for really an excellent piece of work here in front of you. I have only a few minor but very important comments on Rule 1. I have just one. My recommendation to the committee is that you please do not ask the board to withdraw the rule, that you merely ask the board to slightly amend it. On Rule 1, my only comment is on Section 1.11.2 and 1.11.3 regarding the presumptive disqualification of individuals based on their criminal histories. 7 VSA 883 strictly limits the board's authority to reject applicants due to their criminal history. This came out of work in the Senate Judiciary Committee initially, where the legislature decided that it is extremely important that we bring into the regulated market the existing participants, recognizing that the existing participants are quite likely to have criminal history records that may disqualify them under kind of normal course professional licensing schemes. The legislature limited the board's authority, saying that the board can only reject an application based on, quote, factors that demonstrate whether the applicant presently poses a threat to public safety or the proper function of the regulated market. The board, the Cannabis Control Board has, I think, done an admirable job of revising its initial proposal to better fit the restrictions of 7 VSA 883. My remaining concern is where an applicant is rejected by the board, disqualified due to their criminal history, even under the narrow circumstances now allowed in 1.11.2. The board could, but is not actually required to reach out to that applicant to offer them a, let's call it a second bite at the apple, to present mitigating evidence under 1.11.3 to overcome the presumption. And I believe that this current board and its current staff are well-intentioned and likely would reach out to the applicant and seek that information, but they might not. And further, the application window could close, and that leaves the applicant with no opportunity to present additional information. And so I ask that this committee request an amendment to these rules to require the board to place an application in pending status rather than issue a denial wherever an applicant is disqualified due to their criminal history, and give that applicant a 30-day period to respond, even if the application window otherwise is closed. Thank you. That is my only comment on Rule 1.
Any questions for the witness? There be no questions that seem to be clear what you were asking, and you have limited what you've asked for in a clear fashion, and we will pass that along to our colleagues. And thank you for your testimony.
Thank you, sir.
If there are no further questions for the witness, we're going to move on to the second proposed rule of the set of 5. Once again, we have the same 2 witnesses scheduled to speak to 21P38. And this deals with the licensing of establishments. This is the second of 5 rules and the second one that we will deal with today. The remaining 3 to come at a later date. Mr. Scher, you're back up.
Thank you, Mr. Chair.
Second rule in this set of 5.
Thank you. I appreciate the time. I'll keep this introduction much briefer since my prior one largely covered both, really. I did just want to note really briefly on 1.11.3 that Attorney Silberman just brought up. The final sentence of 1.11.3 does require the board. It says license applications will allow applicants to provide additional information related to these factors, meaning these mitigating factors that are listed there, if it's relevant to, only if obviously there is any criminal history issues. So I did just want to note for the board that is there. There is a requirement to, on the initial application, to provide that space, and the board did feel that that was sufficient. Although I understand Attorney Silberman's asking for something slightly additional to that. Moving to Rule 2.
But before you go to Rule 2, do you and Mr. Silberman speak?
Oh, we certainly do, and I'm sure we will right after this.
So I think we would say what Mr. Silberman was asking was, in the spirit of what you just explained to us, that witnesses could come back and the applicants could come back and respond with a chance to provide additional information. I think what the proposal was that you might be the last applicant to be processed and the time would run out. So maybe by the next time you two could come to resolution on that, or maybe not, but so.
Certainly will.
Yeah, that's between.
Yeah, thank you, Senator.
Yeah. So you were going to speak to the second rule. Go ahead.
That's right. On the second rule, so there isn't very much new to say, although I will address the memo that we submitted briefly, and which we appreciate the notes from the Legislative Council. They gave us a couple good improvements on Rule 2 as well. I don't think that they are that clarify the sort of the permissions that integrated licensees will have. I thought those were good catches and very useful. With respect to again, returning to Attorney Silberman's memo, he has 4 notes on the board rules on this. And I will again note that although we're always happy to talk with interested individuals and advocates on these issues, I do want to note that 4 of the 5 recommendations on Attorney Silberman's memo were things that were substantially similar to what the board already considered and already decided not to do. So I will bring back, the board has seen this memo. I will bring it back to them. I suspect that their answer will be the same. And again, I think these are basically policy disagreements. But on the Rule 2 pieces that Attorney Silberman notes, he did have some recommendations to change the warning label in particular across a number of different, with a number of different concerns. Again, the board was statutorily obligated to consult with the Department of Health. The warning label was produced in cooperation with the Department of Health. It has their approval, and the board did not want to make any changes without the Department of Health, and so they did not. They did reach out to the department during the notice and comment period in order to assess whether they should be responsive to some of these recommendations. What Attorney Silberman put forward are some of the recommendations, but there were actually many recommendations coming from both sides. Actually, the medical community, Vermont Medical Society, had some that wanted the warning labels to be basically more, they wanted more on there. Attorney Silverman is looking for a little more flexibility. So we had recommendations coming from both sides of us in terms of the policy preference on this. The board decided to stick with what had been agreed to with the Department of Health, and the Department of Health, when they were, when we reached out to them, did indicate that they would prefer us to keep what they had approved already. And so the board did. With respect to the online advertising piece, again, this is something that the board spent considerable time speaking about already. They chose not to make any changes with respect to the social media piece in particular. Attorney Silverman does raise the question of whether there's an infringement of licensees' free speech rights. This is an issue that has come up repeatedly during the debates about limitations on advertising. It came up during the legislation as well. And certainly we believe that the Attorney General's office, I should say, noted that they believe that the legislation is within First Amendment law, the restrictions are permissible. Attorney Silverman raises the point that there's an unreasonable distinction here between social media and regular websites. And I would just say to that I think any sort of even casual user of the internet understands that there are significant differences between social media and websites that say a company's website that you go to through a web browser. And in terms of the shareability, the ability for people to spread things among peer groups through online groups, social media is qualitatively different. The board, recognizing that, did increase in a narrow way, increased restrictions on social media, but did not ban social media advertising. I want to be clear on that. Just made some product placement a little more restrictive or made it more restrictive on that. And we think that that is defensible legally and was a reasonable policy choice for the board to make given public health concern.
Forgive me, I'm going to interrupt you because we were going to hear about the second rule, and the time to rebut Mr. Silverman's concerns would be after he's made them, and let him, he'll be making them for himself, I assume.
Sure, my apologies.
And so for if you could share us what the second rule does, and then we'll take it from there.
So certainly, Senator, my apologies. Second rule
is complicated stuff, and it's tough for us all to keep track of how the process works, particularly with 5 rules. So the floor is yours. Rule number 2. Yep.
Certainly, and I apologize. I think I over-relied on my first introduction here. The second rule.
Hey, it's work in progress. The floor is yours. Go ahead.
The second rule, as we discussed briefly before, is the general regulation of cannabis establishments, and it's in some ways perhaps the key rule in the whole structure, because it does lay out the ways in which all cannabis establishments, and also that will affect the medical program as well. Some of the requirements will be applicable to the current dispensaries or future dispensaries should they come online, and lays the rules of the road for every type of cannabis establishment, for transportation of cannabis and cannabis products, for storage, for testing, for all the consumer safety pieces of it that is essential to making this a workable and trustworthy market. It's doing a lot of heavy lifting. We think that the board believes that they have found a good balance between allowing for a market that is tightly regulated enough to ensure public safety and consumer safety, while also allowing commercial actors the flexibility they need to run businesses that will be profitable or at least able to survive and function. If that doesn't work, then we've also, then there's also a failure there if it's so tightly regulated that there can be no market. So I think that the board's worked hard to find that balance. The board believes that they have found that balance. And of course, the board understands, as I mentioned before, that they will be returning to these rules once experience teaches us where there may be issues. But I think that this rule does do it is very cognizant of the policy issues that Senator Benning very nicely summarized before, and believe it does address each of those, and happy to take questions on any pieces of it. It is a big and key rule.
Good. Are there any questions? Thank you for your presentation on number 2. Are there any questions for the witness?
If I could, Mr. Chair, and I don't know how this fits into it, but again, serving on government operations currently, we had a drive-by of H548. And I'm just wondering if you're familiar with that bill. It does a lot of the things that you've just talked about, whether it's, how to distribute, how to package. And I'm just wondering, I know we're at the current rule here, but any thoughts on, would it be done the whole rule process again if H548 went into effect? Are you familiar with that at all?
I am, and that's actually a really good question. So one of the challenges that we've faced is knowing that there are likely to be amendments like H548. There's a few other bills out there too, that will change the statute as we're writing the rules, or just, after the rules are completed. We were very cognizant of that and made every effort to design the text of the rule in a way that, should the statute change, that change will be automatically incorporated into the rule. The way we did that was simply, instead of restating statutory language in the rules, we almost never do that. We almost never restate statutory language. We simply reference the statute. Whenever we say you have to abide by XYZ regulation, we say you have to abide by the regulations in X statute. And we are hopeful that by using that strategy, any of these amendments in 548 or in any of the other bills that are potentially going to be passed this year, that it will not create an immediate conflict. Over time, there's no question that rules will have to be amended to accommodate increasing changes that come through the legislature, but we are hopeful that we've designed these carefully enough that any amendments that get passed this session will sort of automatically be incorporated because of the way we drafted the rules.
Thank you very much.
So I think we've exhausted our questions. We have 10 minutes left. And if Mr. Silberman has some comments on the second of the 2 rules.
Thank you.
Understanding if he has concerns about, sections 3, 4, and 5 that we haven't dealt with yet, he will present those at a different time when they come up. Mr. Silberman, the floor is yours.
Thank you, and I appreciate Attorney Scher's pre-buttal. It is always good to have an open debate, and I do appreciate his availability to discuss these issues at all times. Section 2.2.9 of the rules on packaging has a absolute prohibition on the use of plastic in packaging. I'm not quite clear where the board felt its statutory delegation of authority was to ban plastics. I think the legislature gave the board a series of priorities to instill in its licensing process that included environmental sustainability, but I don't think that the legislature contemplated that the board would ban the use of the most common types of packaging altogether. And also, the ban on the use of plastics may make it very, very difficult and or expensive for licensees to comply with the statutory requirement to use childproofing on packaging. So I brought some samples I hope you can see. This is a metal tin of 42.5 milligram, 40 each, 2.5 milligram THC mints from a store in California. This is a metal tin, but it has a plastic childproofing rig. So you have to press and lift, very hard to do. It's plastic. This is not allowed. Here is a glass container with a wood top, also from California. This is a topical. It's a really nice pain relief lotion. Plastic on the inside to keep the product from drying out. Another common edibles package is a completely plastic bin that you have to press really hard on the side to get the top to open. And here is a typical pre-roll This is a half-gram pre-roll. It comes in a test tube. Test tube is plastic. These are very common containers in many jurisdictions. None of them would be allowed. It would be very difficult to have effective childproofing without some use of plastic. And I'm also concerned that if we have to choose the most expensive packaging, that will increase the price to the consumer. That'll make it more difficult to bring consumers into the regulated market away from their existing sources, which, by the way, you can get edibles, topicals, vapes, everything from the illicit market today. That's it on packaging. Senator McDonald, do you want me to go through each one or pause at the end of each one?
We got 5 minutes.
I'll continue.
We have 5 minutes, and that is clear.
Yep.
What you suggest?
The next is on labeling. You know, the Department of Health, the content of the black box label formulated by the Department of Health, I actually think that the content is mostly fine and appropriate. The problem is that it's quite inflexible. So for example, it requires that every product, every ounce of flour sold or whatever, have a warning on it that says the effect of edible cannabis can take 2 hours to take effect. And that it has to be on every product, even if it's not an edible product, even if it's a vape, for example, that will hit you right away. And I think that is potentially confusing in a harmful manner to novice consumers, specifically the kinds of consumers who these warnings are made for. And so it's important to be clear. And I think so my recommendation is that you only include the warning about edible products taking 2 hours to take effect on edible products that take 2 hours to take effect and not on all products. Additionally, the black box warning, which you have to print without change, refers in a couple different places to this product. And that's fine when it's on a package, but the black box warning by rule also has to be on every piece of advertisement. So if I, let's say, own a store and I'm putting an ad in 7 days, advertising my store, but not any particular product, I have to put on that a warning saying this product contains cannabis. But it's just an advertisement of a store. There's no product being talked about. It's weird, it's confusing, and I wish there were more flexibility so that we could provide consumers with relevant warnings and not irrelevant warnings. Additionally, there's 2 requirements that specific labels be affixed in 10-point bold font. I've gone and printed them out in 10-point bold Times New Roman font. And this is the size that you end up with. Contains multiple servings, keep out of reach of children. And this is a lot of real estate on a very small package. So take, for example, a 1 gram flower package. This is what a gram of cannabis flower looks like. This is, kind of very small packaging. This takes up about a quarter to a third of one side of the package. That's just these 2 warnings. We still need to put a universal symbol on it, actually 2 of them. Each one of them, if you look at your thumbnail, it's about a 1/2 inch by 1/2 inch is the requirement. So you need 2 of those on the package as well. And you need to accommodate the black box warning. On a package this small, unless you make that black box teeny tiny, I'm not sure where you put all of these things while still having room to describe what's inside the product. And so I ask that you request an amendment to the size requirements to allow smaller sizes in order to accommodate smaller packaging. When, if we do not, what will happen is instead of selling grams in small containers, you'll end up selling grams in big containers to accommodate the packaging, the labeling requirements, and that will just lead to more waste and more expense. That's it on labeling. On advertising, the board's rules allow advertising on age-gated websites. That's a website where you have to click to confirm you're at least 21 years old before you see the advertisement. The board does not allow any advertisement that has a picture or text describing a product on social media other than a link to the operator's static website. This is true even where the social media website employs age gating. And many social media platforms do have an option for age gating where to view the content, you have to confirm you're 21 years old. I believe this is an arbitrary distinction. If you allow one type of website, but not another type of website to have these advertisements with age gating, that seems arbitrary. And it also is, in my view, an overbroad restriction to not allow anything except links to websites on social media. That's on advertising. And then finally, I think this is the one that the Attorney Share referenced was not something that the board had previously considered. I'll blame myself, I should have raised it earlier. But the rules, sections 2.3.9 and 2.6.6 allow cultivators and manufacturers to produce samples for employees and other licensees. So if I'm a cultivator, I make some samples that I give to a retailer to allow the retailer's employees to try to see if they like my stuff, if they want to sell it. And that's great. But the rules don't allow retailers themselves or wholesalers to produce samples out of their own inventory. And that just seems like, if it's intentional, it seems rather arbitrary. I think it's probably an oversight. There really does not seem to be any public safety reason not to allow wholesalers and retailers to produce their own samples for their own employees, or for wholesalers to produce samples for retailers and their employees. It all would still have to be tracked in the inventory tracking system. It would all be subject to the same rules. But for some reason, retailers and wholesalers are just not allowed to do it. And that is the entirety of my comments on Rule 2. Thank you very much.
Thank you. We're each due at other committees, and thank you for wrapping up when you did. For the public, we welcome witnesses who wish to speak to the rules and make suggestions. Most often, when suggestions are made that go into effect, is when the witnesses speak to the rule proposers, and then together come back and bring us changes. So we will be taking this up on the
March 10th. March 10th.
March 10th is our next meeting, when we still don't have senators in the building full time, but we will, I think we'll have a quorum for that one, and be able to vote on rules packages 1 and 2 of a 5-volume set. Thank you, witnesses, and until we're not formally adjourning because we're not a quorum, but we're finished for the morning, and we appreciated the testimony. We'll pass it along to our colleagues and see if we can stimulate some discussion before the next meeting. We are done.
We don't want to talk about it next meeting.
No.